their health insurance premiums, basically, right? So,
It's W-2.
this is
So
W-2.
if my employer pays my insurance on my W-2, we will report how much they cover.
Right,
Correct.
right.
2013, all employers must put that.
Yes, all employers will be required to include that
50 and
information.
over, what is it, or is it, no, 250 and over
250 and over, yes,
for 2012.
for 2012.
But in 2013, it's everybody.
Yes,
But if you
that
have-
is correct. So that information will now be, because it's considered a tax, being tax liability. All right.
Yes, all employers.
So in closing, again, we want to make sure that if we have not reviewed our handbooks, we want to, make those changes to the leave of absences, make the changes to the information regarding Americans with Disability Act, the ADA, using that language that I gave you, the interactive process and reasonable accommodation. You're going to want to make sure that you understand your Industrial Welfare Commission wage orders, your IWC. I get a lot of people that look at me cross-eyed when I say IWC. Does anybody know what their wage order is? Yeah. Okay. If you don't, you can go to our website or to their website to find out what your wage order is. You are required by law to post your wage order along with your state and federal labor law posters. And some of you may even be under more than one wage order. So you would be required to post all wage orders that apply to you. Something to consider are union avoidance seminars based on what we talked about with the NLRB posters and the new cases that we're seeing come down the pike. Just something to consider if you hear any buzz from your employees about, unions, or they start talking about organizing, definitely something that you want to consider. We're here to help you at CEA if you have any additional questions. I can take some additional questions now, but that basically will conclude our program today. A couple different things before you go. You're not allowed to leave. We have some posters that we're raffling off. I encourage you all to please complete the evaluation form. I'm not sure, do you guys have an evaluation form?
Yes, there is an evaluation form in there. We're going to use that to draw. You're going to be.
No, I mean for finesse staffing. Do they have it on?
Oh, no, we'll email it.
Okay, they'll email out an evaluation form, so you'll just have the CEA form. If you guys could complete that for me. In the meantime, I will answer additional questions while you're completing those forms. If anybody had any questions about, I know we had a few on the brinker. Yes, ma'am.
What if,
Can I get you to fold it in half? I'm sorry, before we go on like this. So I'm going to use this for the drawing for the labor law
Okay.
posters.
Okay. And maybe we'll have Sarah pull those for us. I'm sorry, go on.
what if the employee tells you after the fact, or maybe even the next day, that, oh, by the way, I didn't take a lunch yesterday because I was busy working or had to go do that?
That's a great question. If the employee tells you that they didn't take a lunch because they were busy, you can do one or two things to remedy that. You can go ahead and pay the penalty, and you can discipline the employee. You can actually discipline an employee up to and including termination if they were aware of your company's policy that they have to take a meal in a rest period. But you're going to want to make sure that you have an acknowledgement form that the employee agrees to comply, they understand the policy, and that they willfully just decided that they weren't going to take that, because it doesn't stop them from being penalized from the Department of Labor. That's what this whole Brinker decision is, why it's such a huge deal, because it assesses whether or not an employer can be penalized for either not insuring or just providing. That's what the big brouhaha is about, because if you're just supposed to provide it, then there would be no penalty if the employer by their own will said, we're not going to take our lunch break. Yes. You don't, Scott? We need an evaluation form down here, please. Yes, ma'am.
Isn't there an exception to the meal period if the employee works straight 6 hours?
Yes, thank you. That's a great question. She's asking about if there's an exception. If 6 hours will complete the shift, then the employer and the employee may mutually agree to waive the meal period. However, it is 6 hours, not 6:01, not 6:02, not 6:15. If it goes over 6 hours, there's a meal period requirement. Okay, so 6 hours into the shift, that's it. They clock out, no harm, no foul. No rest period is required as long as the employee agrees. Okay?
No break.
They still get a break. It's the meal period. And again, keep in mind, rest breaks are an easy defense because you didn't get a glass of water, you didn't take a phone call, you can't use the restroom defense. Don't say, well, you went to the restroom, so that's your break. No. But that person, I'm sure, got a cup of coffee or spilled one like I just did. They have gone on the internet to pay their pay a bill that's due that day. They took a phone call from their wife or their husband because or their kid coming home from school. I mean, it's a pretty easy defense as long as you didn't discipline that employee for taking a break. It's the meal periods where there's a requirement of the actual punch that's going to get you. Okay, rest, not so much. That's not to say that, you shouldn't allow them to take it. But again, easier defense. Yes?
Did I hear you say that after 10 hours, they're supposed to have a second meal?
Yes.
Okay.
Yes, and as long as the first meal period, and we have another waiver situation. As long as the first meal period was not waived, then they can waive the second. If 10 hours is sufficient, they can waive that second one. Okay? Are there any other questions? I will still be here. Scott, we've got another one here. Scott's collecting the
You'll just send them down this way
evaluation
for
form?
this
There's
side.
actually a question on this new form.
Oh, I'm sorry.
Notice to employee. Down at the bottom of this, it talks about employer agreement is, and then you check the box either oral or written. I don't understand that.
Well, it is. I don't understand that either because at the end of the day, when you're writing it down, it becomes a written agreement. So it could be that you did not have a formal contract or you didn't have a formal offer of employment. So you could just say, I really like you, Sam. Guess what? I'm going to go ahead and hire you for $12 an hour, start on Monday, that kind of a thing. Where there wasn't an actual offer letter that was given to the employee that specifically states, we're going to.
So although we have all these forms and documents they sign, it still could be oral or is oral?
It still could be an oral
If I don't
agreement.
have something written saying,
Right.
I have hired you?
Right, exactly. And that's why, this Wage Theft Protection Act actually came into play because there was a lot of discrepancy behind whether or not someone made an oral agreement with an employee. So for instance, the employee may have said, well, you told me after 90 days I was going to make, $12 an hour. And, so those kinds of situations where there would be a discrepancy and the burden of proof is always on the employer, not the employee. So, yes.
We have employees like the bonus program, they collect $20 every quarter. Yeah, I would definitely.
If they are non-exempt, yes. Right, if it is a discretionary bonus, no. If it is non-discretionary, meaning that it's based on productivity or a set amount of, sales or a set amount of volume, then yes, you would have to do that. All right, so don't go because we're raffling off the posters. And are we
Can I get clarification on the for 10 hours?
Okay, how many of these do we have? We take two going, we have them all?
Yes, that's correct.
Second rest break.
So we get you out of here?
Yes, as long as
You reckon I'm running over here?
we also have a, if you want to kind of jot that down.
We have one more here. Anybody else with their evaluation?
That'll kind of break down.
Somebody asked me last night.
Normally I make the last person.